The Supreme Court struck down a Texas law designed to make abortion clinics more like actual medical facilities. Will the outcome lead to the death of our constitutional republic? I'm Scott Ott with Bill Whittle and Stephen Green, and this is Right Angle, made possible by members at BillWhittle.com. The mainstream media tends to talk about the outcomes of court cases. On this Right Angle, we're going to examine the process. The now landmark case known as Whole Women's Health versus Hellerstedt was decided by a 5-3 vote with Clarence Thomas, John Roberts, and Samuel Alito in the minority. In his dissenting opinion, Associate Justice Thomas highlights at least two reasons why the majority was wrong to rule in favor of abortion clinics and doctors against the state of Texas. First, Thomas says that in Roe v. Wade, the court decided that women have the right to choose abortion, but the plaintiffs in Hellerstedt were not particular women, but rather abortion clinics and doctors purporting to speak for hypothetical women. In effect, Thomas said, the court established new precedent, granting standing before the court to a third party to speak for those who could speak for themselves. Secondly, Justice Thomas said the court invented a new undue burden standard by which to decide cases, and he said his colleagues apply their ever-growing list of standards in a way that ensures they'll reach preconceived conclusions, favoring more abortion, for example. Now, Stephen Green, the court said in effect that state-mandated clinic standards result in fewer clinics as substandard facilities shut down, thus making it more difficult for a woman to find a place to get an abortion. Aren't you glad that the clinics and the doctors can speak for all of those women theoretically excluded from such health care?
Oh, so much to chew on this. We've upped our standards. Now up yours. By setting standards, you don't necessarily close down the bad facilities. You cause them to raise their standards. Although a commenter at BillWhittle.com, Barbara, she's been with us forever since the PJTV days, and I've just forgotten her last name. Barbara mentioned in the backstage when we were discussing this yesterday on Monday during our conference call that we want less regulation of the medical field, even if it is about abortion. So there's a conservative principle that maybe Texas kind of forgot about. That interesting argument aside, I'm looking at this as political warfare. The left is that they invented lawfare, and they're really good at it, and the right really sucks at it. And lawfare is simply using the courts, using legal proceedings to expand the scope of what's permissible where that suits their needs, and to shut down dissenting interests where that suits their needs. And so what we have here is this precedent described by described by who wrote the dissent, Scott? Thank you. Oh, well, of course. I should have known. Where they've expanded who is allowed to sue. So down the line, this isn't really so much about abortion. This is about expanding dissent so that any one of these Democrat-funded, Soros-funded, whatever groups, any of them now has expanded standing to go before the court to tie things up in legal proceedings and to use left-leaning judges to expand and expand and expand the power of government. I think that more than anything is the scariest part of this decision, and Justice Thomas certainly highlighted that for us.
Well, Bill Whittle, Justice Thomas says that by having multiple standards, the court's majority can virtually choose the outcome it wants regardless of the facts of the case. But what difference would petrified standards make if they didn't result in a fair decision today? In other words, doesn't the court have to be flexible to apply a rigid, aging constitution to modern societal needs?
I'd like to spend a moment talking about that rigid, aging constitution because we've been told ever since we were little kids that there are three branches of government, that they're an equal triangle of power. Each one is looking after its own interests. That would be the judicial branch, the Supreme Court, the executive branch, which is the president, and the legislative branch, which is Congress. But if you look at the actual Constitution, the one thing you'll find is that there's a great deal of instruction on the executive, great deal of instruction on the legislative branch. But what the Constitution actually says about the Supreme Court is shocking. It's absolutely shocking. We all know there are 9 justices on the Supreme Court. Not a word about how many justices are on the Supreme Court in the Constitution. My understanding is as long as there is a Chief Justice, you have a Supreme Court. John Roberts shows up for work, that's all you need. I think the much more, and I'd love to get your take on this.
Don't scare me, Bill.
Well, okay. Clarence Thomas shows up for work, and that's you have to have a Chief Justice. That's all you have to have. As I'm sure some of you know, when it looked like Franklin Delano Roosevelt was going to be overruled in the 30s and 40s because his policies were considered unconstitutional, he simply said, well, then I'll appoint 15 judges or 20 to the Supreme Court, and we'll win that way. It's called packing the court, and of course the people backed down, and we got all kinds of wonderful legislation out of that. But I think, Scotty, and you know more about this than I do, my understanding and certainly my belief is that the founders would simply just have recoiled if they'd had any sense that a 9-member oligarchy of you want to talk about elitists, we're talking about the 9 sharpest, well, there's obviously not the 9 sharpest attorneys in the world because, you know, you got Sotomayor on there. But in any event, and her assistant, or who's the one who gets her coffee?
Kagan.
That's the one. But the point is this. These people are in fact an unelected elite, and they are way out of control in terms of the powers that were originally assigned to them. My understanding was that the Supreme Court was instituted simply to be the top court in the land. If you have a civil dispute or something, then their job was to simply make a decision beyond which there was no decision. This is the final court, and that's it. The idea that they would have the power to kill legislation that was legally enacted by the people of the country through their Congress, I think would have just been anathema to them. I think they would have had an absolute heart attack over it.
Well, you know, the framers of the Constitution, as Bill suggests, envisioned the federal courts with a very limited purpose. They would only take a certain kind of dispute between 2 parties and decide it on its merits. But it wasn't long before the court embraced a higher purpose, deciding whether federal laws were constitutional. By 1868, the 14th Amendment applied the Bill of Rights against the states, thus giving the federal judiciary powers that would have doomed the ratification of the Constitution in 1787. Now, over the years, the court has used a rather broad rational basis standard for reviewing laws, with the idea that the democratic process of elections would allow people to redress bad laws and to eject bad lawmakers, rather than having the court issue edicts that are stamped in stone for perpetuity. But over time, it added intermediate scrutiny and strict scrutiny standards of review. Justice Thomas says this further loosening, in effect, changes the court into a little unelected legislature whose laws are extremely difficult to repeal. Because he didn't get it in court, I'm going to give Justice Thomas the last word here. Here's what he wrote in his dissent. The Constitution does not prescribe tiers of scrutiny. The 3 basic tiers, rational basis, intermediate, and strict scrutiny, are no more scientific than their names suggest. And a further element of randomness is added by the fact that it is largely up to us which test will be applied in each case. The court should abandon the pretense that anything other than policy preferences underlies its balancing of constitutional rights and interests in any given case. As the court applies whatever standard it likes to any given case, nothing but empty words separates our constitutional decisions from judicial fiat. With Bill Whittle, Stephen Green, and the rest of the Right Angle team, I'm Scott Ott, thanking the members at BillWhittle.com for making this possible.